Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Melone Hatley PC, and this is our podcast, I Now Pronounce You Divorce, where each week we talk about issues that our clients are going through that we think are important to pull the curtain back and give you a little bit more information. Last week we started talking about settlement agreements, how settlement agreements work, some of the timing that goes back and forth in settlement agreements. It's not, I send it today, I get it back tomorrow. It's weeks, sometimes even I've seen it take up to a month before you get a response. And we talked a little bit about what happens when you don't prepare for trial, how you can still get a pretty bad settlement. And when you do spend the money to prepare for trial, you'll get a better settlement. And now I want to talk about the sunken cost theory. The sunken cost theory is something that creeps up in almost everything we do, where we say, look, we've invested this much time into negotiations. I don't want to now switch to litigation because I've invested into this negotiation. Let me continue down this pathway. And the reason it ends with the word fallacy is because it's usually not the right thing to do. You haven't invested anything yet. You're just going to continue to lose. So, Rebecca, when and how do you know it's time to cut off negotiations?
Usually it should be earlier. Every single time. We should have done this earlier. Yeah. No, I think it can be worthwhile to send out one, here's my completely uncontested offer, everything on the table. I have all the information. That's the most important piece. And we could be done with this, right now today. If we don't get a really quick yes to that, then we go ahead and we move the process forward with the court. I really don't like these cases that end up lingering and going back and forth, because you're also limited on what information you can get if you haven't filed anything. So we can ask the other side, oh, can you give us your bank statements? Can you give us your retirement statements? Can you give us, the house appraisal that you have, or whatever it might be? And they might give you some of it, right? Or they might give you nothing and tell you to go pound sand. Who knows? But if I have something filed with the court, then I can serve them with discovery and they have to turn it over. And I can send subpoenas to the bank and I can get the information I need. And now I'm in a much better position for my client, to know what they're getting into, to know what they're giving up if they want to give something up, and to move that conversation forward. So for me, negotiation has to run straight alongside with litigation, or else it's basically meaningless. You can have some conversation before you file, but again, I think it is really limited. I've had situations where someone's come in and they've said, look, everything we have is joint. I have all the bank records. I have all the tax returns. I have all the, all the documentation that we would ever need. And this is the agreement that we've already been talking about, and we've already crunched all these numbers. Okay. I mean, that happens once out of every 100 cases, but it does happen. So it's worth a little bit of time and effort. After that, you have to just move forward and get the information, because as attorneys, it comes back down to us too. So there was an attorney in Virginia who had a client come in who said, I don't want any spousal support. I don't want anything. This is the agreement. Can you write it for me? He said, yeah, sure. And he wrote it up and he sent it off and they signed it. And it turns out that she had given up something like $750,000 worth of spousal support that she was entitled to. So she sued him for malpractice, right? And she got a judgment against him. So really, as practitioners, we are not going to recommend that you sign anything unless we can look at the information and give you the advice to say, look, you're giving up $750,000 of spousal support. If you really still want to do it, okay, great. But I'm going to write you a letter and have you sign it that I at least told you, and and then you can give it up if you want to. But otherwise, we're just not doing our jobs if we don't have the information.
Well, we should not do that. He said,
Yes.
we never do that. We as attorneys should not do that. And, we hope that nobody ever would. I will be honest with you. If I have somebody come in who, I'm working with and they won't let me file a complaint for divorce, I usually tell them the relationship's not going to work out. They need to fire
Yep.
another attorney. And,
Yep.
and the reason is I don't want to sit there and negotiate for 7 months, 8 months, 9 months, and then realize that it all fell apart. And now we're 9 months behind. And my client's like, you know what, just sign whatever. It's the sunken cost fallacy. Like, I've invested so much time in it, so much money, just sign whatever. I'm tired of it. This is your fault. Well, of course it's my fault. I did a bad job advising you. I should never have just let us negotiate for 9 months. And I know the case you're talking about. And the reality is, once you do discovery, I've had cases again where I do discovery and I have clients trying to give up horrendous amounts of money. I tell them, I said, I can't represent you. This is illogical to me. I don't care that you want to give up the horrendous amount of money. I can't ethically let you do this. So, Dan, how do you handle this idea that, we've invested so much time in negotiation, let's just keep going down this road? I'll give it all up. Let's just keep going down this road.
I look at it in a couple of ways. And as you were explaining it, the one thing that comes to my mind just from experience is just some red flags. If someone's willing to give up a lot, then it makes me question, okay, what's the intention? Why are you willing to and Rebecca's example is, almost $1 million. Why are you walking away from that? Or in your example, why are you just wanting to give everything up? There's something going on that at least I, from my own perspective and being a practitioner, need to do due diligence to look into what's going on. Because at the end of the day, both of you said it comes down to the lawyer, and I'm not going to have my license on the hook potentially for something that my client was doing illegal that I somehow supported by not doing my own due diligence or being held accountable or liable for it. And you may have to part ways. And those are tough because they come to us for advice, but they're not following or adhering to my advice. Then I think that breakdown in the communication, the representation has happened, and I can't effectively do my job to zealously advocate and represent you. So we have to part ways. And there are times, though, where I've been in mediations, which are basically settlement discussions, and you're there all day and sometimes into the evening. And it does. You're drained and you're exhausted. And I can tell if my client is feeling that way, and we'll just pause and we'll look at it again the next day. Because if there is that true intent to settle, it'll be there in 24 hours. But I don't want any client to just sign something because they're so tired or they're so hungry or they're so hangry that they just want to get out and they'll just sign away everything. Because again, it's going to come back to me. And those are tough too, because I've been in those 12-hour mediations and it's like, yes, let's just get this done. I don't want to deal with this anymore. I paid you 12 hours plus prep time. I'm done. No, let's not just throw in the towel because you're exhausted. Let's go home, sleep on it, and meet me back at my office tomorrow. We'll go over it again. And if it's still something that makes sense, then let's sign it and we'll send it off. But we just want to make sure that we're walking our clients through, and not that they're just wanting to give away the farm because of something nefarious or just because they're just done, right? Or we want to make sure that they've thought this through and they're just tired of going through the process. I mean, the process is there in place to protect you, and we need to take advantage of that. And that's where that whole litigation, in my opinion, comes in, is why we send out discovery, why we send out subpoenas, why we take these depositions, because that will facilitate that settlement. But as Rebecca said, sometimes it happens in the very beginning. It may happen in the middle, or it may happen on the eve of trial or at trial. I mean, I've even been in situations where I was in a 2-week trial, and on the 14th day, we ended up settling. So it does happen. It's just a question of when. But our job is to really advise the clients why we're doing something and how it relates to their case. I mean, we talked about on the business blueprint with values and applying it to employees and clients. It's the same here on what we're talking about now, is how does the law apply to you, and what are we doing to make sure that we're protecting you and moving your case forward? Because I agree with you, Charles. Those cases that just kind of stall for months on end never end well for anybody.
No, they don't. And, you brought up fatigue. There's litigation fatigue that happens over the course of months. There's mediation fatigue. And I think we've all sat there until midnight, 1, 2, 3 o'clock in the morning. One way I would combat that is a week before mediation, my client and I would sit down and we'd write down what they would take. And I'd type it up, just a bullet point list, just for us. And I would make sure that that bullet point list was with me before any sort of agreement was signed. If it didn't hit that bullet point list, Dan, to your point, no, we're going home, man. You hired me to do a job. So, Rebecca, what do you do to combat that fatigue?
Well, I always tell my clients to bring a snack. That you really can't underestimate the importance of having a snack. When you're going to court, when you're going to mediation, whatever it is, when you get hungry and you're tired and there's no end in sight and you just want to get out, I bring a granola bar, bring something. I'm a mom, so I always have like an applesauce on me and a pack of fruit snacks. I'm ready to go at any given moment. But that's something that I prepare the client for in advance. And I say, this is the style of this particular mediator. They want you to get to that point where you're both just like, I don't care. Just give me the paper. It's midnight. I'll sign whatever you put in front of me. So you don't want to be pushed to that limit. So we prepare in advance, having a list of what is your bottom line? What are your non-negotiables? Having a thorough understanding of that. And then I usually write my clients a relatively detailed letter about, these are the things that you want. These are the counterpoints that we can expect from the other side. And this is where I expect the mediator to push you, either to push you or to push them. This is where I would see the mediator, giving a recommendation. And that way it's not the first time they've ever heard it. Mm-hmm. Right. So when we're in that room and the mediator says, oh, well, why don't you just agree to this particular custody schedule? My client isn't like, they have no idea what just hit them. I've never heard of this schedule before in my life. We've at least talked about it as an option, whether or not it's something they want to agree to, and they can confidently say, no, I'm not willing to agree to that. And here is something I'm willing to give on, or, yes, I would be agreeable to that with these additional terms. So if they have an understanding of that going in, we're going to be in a much better position than rather them just feeling like they've been attacked all day and, had to come up with something brand new that they've never been prepared for. They've never, dealt with. And so having that all written down in advance, doing that preparation, packing a snack and a water bottle, and you're good to go.
So I am renowned for walking out of mediations. I remember one time we went into the mediation, and I prepared similarly to what you were talking about, Rebecca. And the mediator came back with such an absurd stance. So the way that worked was, the two parties went and sat in separate rooms. The mediator walked between the rooms, and the mediator started with the other side first, which I was fine with. That's absolutely okay. And they came back, and they were like, well, this really horrid thing that happened, it doesn't matter. No judge would care about that. And I said, well, you're wrong. We're done. Bye. No counteroffer. And the mediator just stood there shocked, because guess what? The mediator gets paid to be there too. And her salary just got cut by a lot because she was there for 40 minutes instead of the 12 hours she was planning on. But I always tell my clients when I'm working with them, don't feel pressure from a mediator, man. It's not their life. It's your life. Right. I don't care if I'm standing in front of the chief judge of whatever court I'm in, and the chief judge tells us to go out in the hall and negotiate a point. And if you don't want to, I am fine with that. I am here for you. And there comes a point where mediation is done and it's time to worry about a court order. I will tell you why mediations scare me. And Dan brought it up earlier. When you sign an agreement, you've signed it. I can pretty much undo an order. I can't undo an agreement. And I'll give a wonderful example. There's special combat military pay. And for a long time, people did not understand how that impacted a military service member's retirement. So the non-service member would agree to get the DFAS regulated portion of the retirement, the number of months of marriage divided by the number of months of service. And that would be the formula that was used. It would be entered. Everybody's happy. It's signed on a contract and agreement. And then the military member would then qualify for some sort of special combat related pay and not have retirement anymore. So they're getting a different fund. And now because you signed an agreement, it's a contract. We can't go back and change it. And I, for a while, was one of the few attorneys in town that knew about that. And so I was watching agreements just come through being like, I can't advise the other side that this isn't right because that'd be an ethical violation of my client. I can't advise them to add this other sentence. However, on the ones that were court orders, we could go back and change it. Because on the ones that were court orders, there was some after discovered evidence which made the ruling illogical. So, Dan, how do you handle that?
Well, if you're talking about this ones that are done by settlement, those are the toughest conversations because you're right. It's usually contract, and they're so hard to get out from anything. There's fraud, duress, coercion, things like that. Those are rare, and even if they may exist, they're even harder to prove because that's in your best interest, right? It's why you're signing it. There's language in there. Now, I have had, and very limited, so those who are tuning in, it's not that I bat 1,000, but there are some to where if it wasn't put on the record, that did allow me a little bit of leeway to have it overturned per se, or at least the court take a look at it and send it back for the parties to renegotiate, or the timing of it between when someone comes in and says, oh, I don't really like this, because there's buyer's remorse. And in my experience, some judges will look at that and say, okay, it's only been X amount of days or weeks, so maybe you can go back. But if they're coming back years later, yeah, there's really not too much that we can do. But on the order side, it depends. And it's always kind of right, the attorney answer. It depends. It's because it's always this or that, or maybe somewhere in the middle. But you could have where I practice, it's called undiscovered marital property. And that's just throughout the course of the proceedings, a certain piece of property, maybe what you were discussing or something else, that through reasonable discovery methods, we wouldn't have known. But for what this event that just transpired, maybe being going out and doing combat, or something else happened with a piece of property that it surfaced, we wouldn't have known. So now we know, and judge, we need you to take a look at this. So we need you to set either the entire order aside, because it may have other ramifications, or maybe just one definitive part of the order needs to be set aside. And so those are when we file the motion to set that aside. And usually if there's an attorney on the other side, they'll agree because it makes sense, right? It's something that happened that neither one of us knew. Or if it's because there's been maybe a dissipation happening after you agreed upon it, instead of going through a contempt, it may make sense just to agree to set it aside. So there are some situations where if we do discover something, we want to make sure that it's based upon, we couldn't have found out the reasonable discovery methods. And unfortunately, there are some examples to where someone's come to me and they said, oh, I found this bank account. Well, in your discovery, you've subpoenaed, your prior attorney subpoenaed these records. Maybe they didn't do their due diligence, but you could have discovered this, and it's just something that we can't handle. And those are tough conversations because they missed out. But for our standpoint and how we practice at our firm is we just want to do our due diligence. And that's why we have case reviews with managing attorneys, just to make sure that we're moving their case forward, but we're also allowing the creativity to think outside the box, to look at those bank accounts. Well, you're seeing things coming in, but nothing coming out, or things going out, but nothing coming in. And maybe we want to follow up on that and kind of just go down that road to see via subpoena what else is out there. So we always want to make sure we're doing our due diligence. But in order to get a court order set aside, there are certain circumstances, but they're limited.
There are. And, Rebecca, when you talk about certain issues that change, do you always come to 100% agreement? Or do sometimes you say, look, we can agree on this, this, and this, but this really should be done through a court order?
Right. So there's a couple different ways to handle that where you have partial agreements. And it really depends on how many things you've agreed on and how close you are. So I've had, for example, clients that will have an agreement about the property, but they don't have an agreement on custody and visitation. And so you can do a partial agreement that just deals with property, the house, the bank accounts, all the financial things. And then we say we're going to reserve custody and visitation for a trial. And now instead of having 2 days of trial, maybe we only have 1 day of trial to deal with custody and visitation. So that's one way you can do it. Another way that you can at least kind of expedite your hearing is to agree to some of the fundamentals. So maybe we don't have a complete agreement about the finances, but we can stipulate for the court, meaning we don't have to present evidence to prove, the husband's income is this and the wife's income is that. And, they agree that they've had the following work schedule, whatever it is that we can just sort of line item say all of these facts we agree to be true. So I don't need to put my client on the stand and ask them, how much money do you make? And we're not going to be attacking bank records over it or anything like that. So that's another way that you can at least agree to like some of the terms without necessarily having a full agreement. And judges usually appreciate that, because it means that, again, your 2 days of trial might now be a day and a half. We're reducing the amount of time and the number of issues for that court to determine. And we're really giving them, an easy way to get to, well, this is the thing that we need to solve. This is the piece that, the court is actually here to intervene on.
Yeah. And, I've got them down to like the parties agree that, party X is going to buy out party Y for 50% of the equity in the home. And then we can't agree on what the value of the home is. Yep. And in that instance, we'll walk into court with that agreement and then say, Your Honor, we just need to bring in our evaluations of the value of the home, our experts. We need to argue it, and we need you to make a decision. Because in that instance, and I've seen people lie and really do weird things in appraisals to where now, if I think that's going to happen, rather than put it to a contract that I can never undo, if it turns out that somebody went and put a bunch of holes in a wall on the day before their appraiser showed up, and we only find out afterwards, I can go back and undo it. That we've had somebody do that. We literally had somebody before the appraiser showed up walk around with a hammer and bash holes in the wall because they were going to get the value of the house as low as possible for purposes of trying to come to an agreement. It's like, no, let's take the value of the house to court. And then they didn't know what to do because the appraiser showed up and was like, yeah, there was just a bunch of holes bashed in the wall. And the other appraiser was like, well, they weren't there when I was there. And we ended up getting the client a lot more money than the client was even thinking about agreeing to, because it was just like, man, this lady is crazy. But, settlement agreements are nuanced, and knowing when to settle and when to walk away and what parts to settle, what parts not to settle is very nuanced. So if you're thinking about going through the divorce process and you're like, no, this is going to be uncontested, rather than start with the idea of being uncontested, start with the idea that I need to make sure that I understand what I need to divide in this divorce. Because if you make sure you understand what you need to divide, then you can worry about whether or not it's going to be uncontested if you divide it or not. And a great attorney is going to walk you through and ensure that you understand. And that's what we at Melone Hatley PC do as your partner in divorce. We make sure that you understand what it is that you need to divide, and then we worry about what is fair. So if you or someone you know is going through the divorce process, give Melone Hatley PC a call and see the difference that a partner can make for you. Thank you.
Thank you for tuning in to our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.